Welcome back to BlocklexTV, your trusted source for everything law on crypto, blockchain, tech, and the digital space. I am your host, Kui Barino Paul. Today, we'll be taking a look at the Nigerian Data Protection Act, an act of the National Assembly which replaced the previous Nigerian Data Protection Regulation put together by the National Information Technology Development Agency, NITDA for short. Let's get started. The Nigerian Data Protection Act 2023, if you ask me, is a comprehensive and progressive piece of legislation. It is designed to safeguard the right and privacy of natural persons domiciled in Nigeria in an ever-increasingly digital world. President Bola Ahmed Tinubu signed this act into law in June this year, and it is poised to reshape the data protection landscape in Nigeria. As data-driven technologies continue to gain prominence in society, the Nigerian Data Protection Act 2023 aims to create a robust regulatory environment that promotes responsible data processing, enhances data subject rights, and builds trust between data subjects, controllers, and processors alike. The Act has a broad scope. It applies to all data controllers and processors, whether they operate within or outside Nigeria, as long as they process the personal data of Nigerian residents. This includes public and private organizations, government agencies, and not-for-profit entities. To oversee the implementation of this act and ensure compliance, the Nigerian Data Protection Commission has been established to replace the erstwhile Nigerian Data Protection Bureau. The Commission is a body corporate and an independent body. It will play the crucial role of overseeing the implementation of the Act and the overall enforcement of data protection regulation, ensuring transparency and upholding data subjects' rights. The core principle of data protection outlined in the Act emphasize fairness, transparency, and legitimacy in personal data processing. Data controllers and processors must collect data for specific and legitimate purposes and ensure that further processing aligns with these intentions. When it comes to lawful data processing, the Act sets clear guidelines. Consent from the data subject remains the primary basis, provided it is freely given and remains unwithdrawn for the specific purpose. There are other legal bases like fulfilling contractual obligations, legal obligations, protecting the vital interest of either the data subject or others when the data subject is incapable of giving consent, and pursuing the legitimate interest of the controller, amongst others. These other legal bases for the processing of personal data must be approached courteously to prevent any likelihood of infringing on the right of the data subject. Data controllers and processors have specific obligations when engaging with others in data processing. They must ensure compliance with the principles established by the Act, uphold data protection standards, and notify relevant parties when new data processors are engaged. The Act addresses the processing of sensitive personal data such as racial or ethnic origin, political opinions, and medical information. It outlines conditions under which such data can be processed, emphasizing explicit consent and other specific scenarios where such processing is allowed. When dealing with children or individuals lacking legal capacity, the Act establishes guidelines and exceptions. It highlights the importance of parental consent, age verification mechanism, and create exceptions for specific purposes like education and medical care. The Act mandates the appointment of data protection officers within organizations engaged in significant personal data processing. Data protection officers play a vital role in ensuring compliance with data protection laws, providing guidance, and maintaining communication with regulatory authorities. On the right of data subject, the Act empowers individuals with rights such as information access, consent withdrawal, objection to processing, protection from automated decision making, etc., etc. This bundle of rights grant data subjects a reasonable level of control over their data and related processing. Data security is a top priority under the Act. Data controllers and processors are required to implement technical and organizational measures within their system to ensure maximum security for personal data, barring unauthorized access, loss, and breaches. In case of personal breaches, the Act outlines steps that must be taken. It mandates prompt notification of the Commission and the data subject at risk whenever a breach occurs or is likely to occur. The data controller or processor must also take firm steps to mitigate the risks that may arise from such breach in order to minimize any adverse effects. Regarding cross-border data transfer, the Act allows data to be transferred to other countries or international organizations only if adequate protection measures are in place within the recipient jurisdiction or organization. The Nigerian Data Protection Commission plays the role of determining this adequacy. Data controllers and processors of significance must register with the Commission, providing detailed information about their operations. This transparency ensures effective data handling practices and supervision. Enforcement is a critical aspect of the Act because what is law without enforcement? Where a breach has occurred or is suspected to have occurred, the data subject can lodge complaint with the Nigerian Data Protection Commission, which has the power to investigate, sanction, and issue compliance orders. Data subjects can also approach the court to enforce their rights. The Nigerian Data Protection Act 2023 is a significant step towards safeguarding privacy and fostering data security of Nigerian citizens and residents. It is a comprehensive and forward-looking legal framework that balances the need for legal processing in the digital age with the need to protect the fundamental rights and privacy of individuals. It sets clear standards for organizations handling personal data, promote transparency, accountability, and empowers individuals to have control over their data. The Act represents a significant step forward in safeguarding privacy and fostering data security in Nigeria. Stay tuned to BlocklexTV for insights on laws and regulations having bearing on the digital space. I am Paul. Thanking you for watching.